Good evening. I'd like to commence our proceedings by acknowledging the Wurundjeri people of the Kulin Nation, the traditional owners of the unceded lands on which I work, and I would like to pay my respects to their elders past, present, and to their emerging leaders also. Good evening if you're in Australia. Good early afternoon, late afternoon across the region, and a welcome to your day in other parts of the world. I'm Professor Pip Nicholson, Dean of the Melbourne Law School, and it's an incredible pleasure to welcome you to this year's Francis Gurry Lecture on Intellectual Property, featuring our guest speaker, Daren Tang, Director General of the World Intellectual Property Organisation. Before I talk very briefly about the Francis Gurry Lecture Series, I'd like to address a few housekeeping matters. First and foremost, the chat function has been disabled, but we do encourage your questions. We just ask you to put them through the Q&A function. Professor Andrew Christie and Ms Janelle Borham, President of the Institute of Patent and Trademark Attorneys of Australia, will collate the question and put them to the speaker as time allows. I also wanted to let you know that this evening's proceedings are being recorded and will be available from our website shortly following tonight's presentations. Professor Andrew Christie, who has coordinated this lecture series and is the Director of the Intellectual Property Law at Melbourne Law School, will introduce our guest speaker shortly. But let me now briefly make a few comments about the lecture series. The Francis Gurry Lecture on Intellectual Property Law was established 12 years ago by the Melbourne Law School, but in conjunction with the Institute of Patent and Trademark Attorneys of Australia. This partnership with IPTA is one of which the Law School is particularly proud, and it is a great pleasure to have Ms Borham here tonight with us. The lecture is named in honour of the Law School's distinguished alumnus, Dr Francis Gurry, a former lecturer, indeed, here at Melbourne's Law School, and some years later, Director General of the World Intellectual Property Organisation from 2008 until 2020. I'd particularly like also to acknowledge the continued support from our event sponsors, the Australian branch of the International Association for the Protection of Intellectual Property, the Intellectual Property Society of Australia and New Zealand, and the Licensing Executives Society of Australia and New Zealand, and also particularly IP Australia, whose Director General, Mr Michael Schwager, is with us tonight and offers comments at the conclusion of Mr Tang's lecture. Thanks to you both for joining us. Andrew, I will now turn to you to introduce our speakers. I would, just before doing that, like to thank Andrew for his instrumental role in designing tonight's webinar on the future of intellectual property and WIPO in a time of crisis and opportunity. Over to you, Andrew.
Thank you very much, Dean, and I add my sincere thanks to IPTA for this wonderful joint venture that's continued to deliver, I think, well for all the stakeholders of IP in Australia, and to key representatives of those stakeholders, which are our sponsors. So thank you to AIPPI Australia, IP Australia, IPSANZ and LESANZ. I've had the good fortune to be visiting Singapore regularly for work purposes over more than 25 years. And that's coming close to half of the life of the country of Singapore when it became an independent state 56 years ago in August 1965. I wasn't there for the first 30 years, but I read about them, and I found particularly informative the various books put out by Singapore's first and long-serving Prime Minister, Lee Kuan Yew. And anybody who would like to know about the phenomenon that Singapore has been, I commend to you any of those books, but in particular the one in 2000 titled From Third World to First. And I learnt in that book that when Singapore was expelled, as it was, from the Malaysian Federation in 1965, it had effectively no physical resources, not even a secure water supply for its people. However, it did have one absolutely critical resource, an intangible resource, its human capital, its people. And as Lee Kuan Yew explains, and as Singapore has exhibited extraordinarily well, it is built on that one resource to become the extraordinarily successful country that it is today in various ways, not just economically, but in particular economically. And as we know, it's got one of the highest GDPs per capita in the world. Our speaker tonight actually exemplifies that focus that Singapore has had on human capital and intangible resources. He himself has been invested in by Singapore and returned that investment in spades through his public service. Has a law degree with honours from the National University of Singapore, a master's degree with distinction from Georgetown, and has undertaken the Advanced Management Program at Harvard Business School. And he's applied his great human capital to help develop the intangible resources of Singapore, especially through his public service in intellectual property. Prior to taking up his role as Director General of WIPO last year, Daren Tang spent 7 years at the Intellectual Property Office of Singapore, IPOS, and was instrumental in continuing and expanding Singapore's great focus on encouraging the creation and facilitating the good management and the appropriate protection of intellectual property. And that's been a huge basis for Singapore's success. I first met Daren when he was at IPOS, and I was struck by two things. I was struck by his character and his intellect, and you'll be struck by them tonight too, I'm sure. His character is personable, direct, and positive, and his intellect is clear, focused, and visionary. So it's both with great pleasure and great anticipation that I now invite to deliver the 2021 Francis Gurry Lecture on Intellectual Property, the Director General of the World Intellectual Property Organization, Daren Tang.
Thank you so much for that very generous introduction, Andrew. It's such a pleasure to see you again. Thank you also to Dean Nicholson for being with us. Thank you to Janelle with IPTA. I understand that IPTA and the University of Melbourne have been partnering on this series for 12 years, and it's an honor for me to be here with all of you this evening. Good morning and good afternoon to those of you joining us from all over the world. It is not every day that one is asked to give a lecture in a series named after one's predecessor, but it is certainly a great honor for me to do so, because Francis Gurry, a son of Melbourne who became a citizen of the world, dedicated his life to WIPO, shaped it in profound ways over his many years of service here at WIPO, and in doing so, heavily influenced the development of the global IP ecosystem. And my talk this evening is entitled The Future of IP and WIPO in a Time of Crisis and Opportunity. And it is a somewhat dramatic title, but we are in the midst of a once-in-a-century pandemic that has taken lives, destroyed livelihoods, and torn families apart. Many of you in Australia, and I have some relatives in Melbourne, have lived through this in the past 18 months, and it's not been easy at all. But at these moments, while it's not so easy for us to see that because in the midst of this crisis, we must also see this as an opportunity to reimagine the world of IP. This must be the task before us, because in the world where the pandemic has accelerated pre-existing trends towards innovation, technology, and digitalization, we have to step up to the plate to meet these challenges. And indeed, what we are seeing, the data that we see at WIPO shows that the sectors of the economy connected with IP, innovation, and creativity have displayed a strong degree of resilience during the pandemic. Last month, WIPO published the 2021 Global Innovation Index, which found that patent filings, R&D expenditure, and venture capital activity all grew in 2020, despite the deepest economic contraction of modern times. And this trend is not just in certain parts of the world, but all over the world, from Asia to Oceania, from Europe to Africa. Key innovation metrics have remained strong. And even in Australia, we've seen trademark applications begin to climb up counter-cyclically last year, up 8% at the same time that the Australian GDP was recording its steepest decline since the records began. And this year, just coming out from my many conversations with the DGs of IP officers, the sense is that the trends in 2020 have continued in 2021. So we're seeing that all over the world, innovation, creativity, and IP remain strong. Activities remain very strong. So that's one first trend I want to share with you, which is that these are areas in which remain very resilient. And when we zoom out of the pandemic and we cast our eye on slightly longer term trends, it's also evident that the events of the past 18 months have not stopped the decades-long shift of the IP center of gravity to your part of the world, to Asia Pacific. 2 decades ago, 4 out of 10 IP applications originated from Asia. But last year, this number was close to 7 out of 10 IP applications. China is now the largest filer of international patent filings before WIPO's PCT processes. And the countries that are improving most consistently in the Global Innovation Index over a long period of time, over years, are dominated by Asian economies like Vietnam, India, and the Philippines. And so what we're seeing is that not just its innovation may be remaining resilient, but this resilience and this globalization of innovation potential activity that has started to shift and started to become part of the phenomenon all over the world will continue in the decades to come. And lastly, as economies and enterprises innovate and create, what's interesting is that asset creation in these enterprises and economies shifts from tangible assets to intangible assets, not just human capital, but IP, data, know-how. And what's been happening is that over the last 50 years, the value of intangibles in the S&P 500 rose from 20% in 1975 to close to 90% last year. Global intangible asset value is estimated to be over $65 trillion US, which is more than the US and Chinese economies combined. In such a world, we believe, and I believe at WIPO, that the global IP community cannot be satisfied with business as usual. Instead, as the experts and custodians of an area that's of increasing importance to every part of the world and of critical importance to overcoming the pandemic, we must now use this as an opportunity to engage with the world, demonstrate our relevance, and step out in a way out of the shadows of the technical areas of IP into the light of the policy areas of IP. And this is why in WIPO's latest medium-term strategy plan, which spells out what we want to do at a strategic level over the next 5 years, and has just been endorsed by the WIPO member states 2 weeks ago at the General Assembly, we laid out a vision of a world where innovation and creativity from anywhere is supported by IP for the good of everyone. To make this happen, we have to continue being good at what we are traditionally good at, to provide top quality international IP services, set international norms, and bring people together to discuss IP issues. But this is no longer enough. We must also now bring IP to the grassroots, so that it's not just relevant to a small group of IP insiders, but to innovators, creators, and people everywhere. We must connect different stakeholders to IP, whether they are artists, musicians, entrepreneurs, business owners, researchers, or even indigenous communities, in a way that they see IP as being relevant to them, and they see the value in IP that we see. And we must use our expertise and knowledge to help others use IP as a powerful catalyst for jobs, investments, business growth, economic development, and social vibrancy, so that we break away from this false narrative that IP is only for industrialized economies and not for the developing countries or for the global south. This is not a revolution, but an evolution, because already many national IP officers and countries have been rethinking their roles and the value of IP even before the pandemic. IP Australia, for example, and I'm very glad that Michael is joining us today, has been one of the key players in a growing community of IP officers that look at IP from an economic angle, taking a multifaceted approach that combines the legal, economic, and developmental perspectives towards IP policy making. And in my unique vantage point now as the first DG to enter WIPO from a national IP office, I know that many IP officers are no longer seeing themselves as IP registries and regulators, but as innovation agencies helping to build the innovation ecosystems of their countries and of the regions. So the work ahead to build a more inclusive global IP ecosystem also means that we must reach out more energetically to those that have been underserved by the global IP ecosystem: small and medium enterprises, women and youth. And each of these present considerable challenges. For example, the latest SME scoreboard from the EU IP office found that the main reason European SMEs have not registered their IP rights was simply a lack of knowledge about what IP is and how it can benefit their businesses to grow. The percentage of respondents citing this as a factor has increased, in fact, in recent years from 25% to 38%. A study, I think earlier this year or late last year, by the European Patent Office and the EU IPO also showed that in the European region, SMEs that use IP as part of their business generated close to 70% more revenue per employee than those that did not. And yet, in the European region, only 9% of SMEs filed IP. Think about the situation in other parts of the world where there is less maturity in the IP ecosystem. On women and IP, the statistics speak for themselves. Despite steady progress in recent years, fewer than 1 in 5 inventors listed in PCT patent applications last year were female. It's sobering to think that at the current pace of change, gender parity in IP applications in patents will not be achieved until 2058. So we need to raise our ambitions a lot higher than that. Youth is also an area of priority for us, simply because they are future innovators and creators. And in many parts of the developing world, a large part of the population is in young people. For example, in Africa, youth constitutes 65%. People below 30 constitute 65% of the population. And if we do not reach out to them and make them feel that IP is relevant to their lives, when they become future policy makers, future opinion makers, future industry leaders, future leaders of their countries, will see IP is not relevant to their work as well. And that's not good for the whole IP ecosystem. So how do we begin to address this? I would be happy to share a few details here, and I would love to engage more during the Q&A session that follows. But first, I think we need to be much better at communicating the value of IP to everyone, everywhere, rather than focus exclusively on the technical aspects of IP. And there's nothing wrong with talking about the technical aspects of IP within ourselves, within communities that are expert, but we need to go beyond our own communities or expertise and go out there to tell stories about how IP has shaped the lives of people on platforms and channels like social media. And this is why WIPO's Twitter feed is now showcasing how we're supporting female entrepreneurs in Uganda, how we are aiding small businesses in El Salvador, and how projects like WIPO for Creators will help musicians understand IP from a musician's perspective. But changing the narrative around IP is useless if it isn't accompanied by initiatives that deliver practical results on the ground. And now it's to Australia's credit that the issue of SME participation in the IP system has received considerable attention in recent years. Beyond policy measures such as the fast-track service for SMEs and the experiment with the innovation patent, the Motley Review produced a series of active recommendations on how to further engage SMEs with the Australian patent system. And impact is also at the heart of the work that we have here at WIPO. One of the key features of our strategy is a step change in how we approach the development agenda. WIPO as a UN agency needs to put behind us development in the form of seminars and workshops and start working on projects that can deliver real results and change the lives of people on the ground. This is why in Uganda, we have pioneered a way of working with the government and civil society to support a group of female entrepreneurs, not just for a few days in form of a workshop, but to accompany them on their business journey over a few months to allow them to see how IP can be a tool for them for business growth. And we're very pleased that out of the 20 female entrepreneurs in Uganda that started out with us, 12 have remained on this journey with us, and they're beginning to use IP as part of their business strategy. Before you get the wrong impression, WIPO's traditional role as a setter of norms and convener of meetings will also continue to be important. But let me be candid with all of you and share a view that the ability for not just WIPO, but for all UN agencies to move big norm-setting initiatives has become a lot more fraught. The reasons for this, which are essentially geopolitical, are often out of the hands of the UN agencies themselves. But we will try, and we need to push for this. But I think this is a world where we need to broaden our perspective on what movement and progress in norm setting will look like. And I believe that guidelines, recommendations, and other softer approaches that focus not just on harmonization, but on making our systems of law and our systems of policy more interoperable will become more common. In this environment, WIPO's function as a global, neutral, and expert forum to discuss, engage, exchange, and share best practices on important IP issues continues to be more relevant than ever. AI is one issue that's been uppermost on the minds of many IP officers, and issues such as whether AI-generated inventions deserve patent protection raise fundamental and difficult issues, which all of us in the IP community need to engage with seriously. I'm therefore pleased that WIPO's recent IP and Frontier Technology Conversations, where Michael participated, and I think there are over 1,300 other participants, remains a forum where such issues can be discussed and debated. But as a UN agency, we also have to orientate ourselves towards action and practical impact whilst debating these important, slightly more conceptual issues. This is again an area where IP Australia is showing leadership as an agency that's amongst those in the forefront of using AI and technology to transform its operations and engage with its customers in a very different way. But there's also another area which I believe can have just as sweeping an impact as frontier technologies, but which I think doesn't receive quite the same level of attention, and that's IP valuation and finance. As I mentioned, the rise of intangible assets and the shift of asset creation towards intangibles represents a seismic shift in the global economy. But while this dynamic continues apace, we still do not have a globally accepted way of valuing or financing intangible assets. This creates two problems. At the macro level, governments, policymakers, economists, and financiers lack a complete picture on the role of intangible assets within domestic and global economies and its connection to trade, finance, and other aspects of the modern economy. This blind spot complicates policy choices and the policy-making process. At the enterprise level, the complexities involved in valuing intangible assets prevents many innovation and creative-driven startups and SMEs from leveraging what's often the most strategic asset, their intangible assets, to have access to the financing that they need to scale and grow. At the policy level, a number of countries around the world, in Asia and beyond, have tried to experiment with various measures around IP-backed finance. China, South Korea, Turkey, Japan, Singapore come to mind. But in truth, this remains an emerging policy area where firms and enterprises and governments are still testing the waters to see how they can better support IP-rich enterprises to grow through IP-backed financing. So to move this conversation forward, WIPO is producing a series of country reports, and our first that was developed alongside the IP Office of Singapore was launched in August. But we're planning to not stop here, but to start a whole series of high-level dialogues, bring in agencies like IMF and World Bank to focus on these issues from a holistic angle. And here's where we believe WIPO can play a constructive role. So ladies and gentlemen, I want to spend some time engaging with you, interacting with you. So in conclusion, I will say that we're all navigating a world in transition. And while the journey ahead of us will not be easy, we do know that innovation and creativity will remain an essential part of who we are and key to finding solutions to the challenges ahead. WIPO's belief is that we as a global IP community must step up and make clear our intention to contribute to these challenges, make IP relevant to everyone, everywhere, and help people see that IP is an important tool for great ideas to make a positive impact in the world. We hope that you'll join us to seize this opportunity and bring alive our vision of a world where innovation and creativity from anywhere is indeed supported by IP for the good of everyone. Thank you very much, and I look forward to the Q&A session.
Thank you very much, Daren. That was outstandingly good, as I knew it would be. And already the Q&A is filling up with questions, so I'll go straight to them.
Sure.
First, question, which begins with a comment, and it's a flattering one and leads to a question. Thank you for your fascinating presentation. You mentioned IP officers are taking a more economic-centred approach to IP policy. It seems though, and despite some recent pushback against the US FTC, that antitrust regulators and economists generally are suspicious of the basis for IP rights. What is the current WIPO approach to the interaction of IP with antitrust regulation?
Thanks, Andrew. It's a good question, and I think if we zoom out a little bit, there's always been a bit of a suspicion on the part of some economists on IP rights. When you read the literature on in those circles, and I may be a lawyer by training, but I'm actually a frustrated economist by sentiment, being a trade negotiator for many years. If you read the views of quite a number of economists, and including the Economist itself, there are occasional articles attacking IP as a monopoly. And I think the argument is that all monopolies are bad, and therefore IP right as a monopoly is in that category as well. I don't think things are that simple. The fact is that the IP system has existed for several hundred years, The modern IP system has been around for about 120 years. And it remains still, it's not a perfect tool, but it's still a very powerful tool to incentivize innovation and to allow people who innovate and create to be able to have the fair rewards in this. So I think first of all, the fact that there's some economists that are uncomfortable with IP, I think it stems from a larger discomfort with monopolies in general. And we see that trend come and go. WIPO has not touched IP and competition for quite some time. But what we have done, and the new administration has done, is that we are going to revive this whole conversation around IP and competition. And right now, there's a team that's led by an expert in this area from Italy, who is going to restart these conversations. So we hope to be able to bring this conversation back. We think it's important because we believe in a balanced IP, and IP is a very powerful tool, but it needs to be wielded with skill. And to wield it with skill, right, you need to have the economic perspective, not just the legal perspective. In fact, you need to have the social perspective as well. So the other thing that we're trying to do at WIPO is to help member states to be more sophisticated in looking at IP, not just from one perspective, but from the multifaceted perspective that IP Australia exemplifies, and many other IP officers are trying to do. So I think it was 2 years ago, it's not during my time, but during Francis' time, that there was an attempt, right, to bring all of the chief economists of the IP officers together and to engage more generally with the economic community, with the community of chief economists. So we hope that all these things will begin to enrich the policy making in different countries, and perhaps show that the approach to economic perspective of IP, right, has to be nuanced as well. So I think I hope that we get your support for that, and we get IP Australia's active engagement in this.
Thank you, Janelle.
Yes, thank you, Daren. One of our attendees has asked about WIPO's work on educating the population in relation to IP, and kudos to WIPO for their work in that area. What role do you think universities play in this journey of making IP more relevant to youth?
I think the universities play an absolutely critical role in this journey, and I think what we are trying to do is that we're trying to when we look at youth, we're looking at people between the ages of 15 and 35. So that's our definition of youth, which I think is aligned with the UN definition. And I think that even at high school, right, we need to reach out to them. But the universities is really where they play a critical role, because the universities is when people start thinking about careers and start picking up skills, right, that become relevant to them as they enter the workforce. And I think one of the things that we're trying to do is that we find that first of all, right, we're trying to increase the number of places in the world where universities are able to offer IP education as part of the curriculum. So WIPO, as you know, has got a WIPO Academy. Last year, the Academy trained 150,000 people, not through the Academy's auspices alone, but through partnerships with many different universities around the world. And you'd be interested and quite fascinating to find out that many of these universities are in developing countries. So you've got partnerships with the University of Dar es Salaam in Tanzania, in many other parts of Africa and Middle East. And so I think that's something that we hope to start scaling up a little bit more. In developed countries like Australia, my exhortation is to, traditionally it's been taught in law schools, and I think Andrew and Dean Nicholson are at the forefront of this. University of Melbourne has been one of the top IP law schools in the world. But I think we also need to start teaching IP in business schools and in the science faculties and engineering faculties, because a lot of their work nowadays as entrepreneurs or as business owners or as scientists and researchers, a lot of the work will touch on IP. They do not need to learn IP to the level of being an IP professional like the people in IPTA, but they need to know it enough so that they are educated that IP is an issue and IP is part of what they need to know. Just like in any education, right? In these schools, they need to know other basic skills like basic finance or or so I think IP, innovation, and creativity have to be taught alongside and probably as third, fourth year options. So one of the things we're trying to do with developed countries to encourage the universities to set up IP modules in these other faculties as well. So I would encourage Dean Nicholson and Prof Christie, right, to reach out to the other faculties in the University of Melbourne and to say that, can we offer your final year business students or engineering students or science students, because they're going to be encountering innovation more and more. So can we offer a chance to give them a 3-credit option in IP? They don't need to be IP professionals, but they need to be IP savvy so that they can then talk to the professionals and they know that need help. And then lastly, I have to say that the universities are also absolutely crucial because they do research on IP. And that research influences public policy making and influences the public discourse. And what we are seeing sometimes is that we are seeing in some parts of the world a very negative discourse on IP emerging, where IP is seen as, to put it bluntly, a way for rich people to get richer and a way to exacerbate income and inequities. And I think we need to be able to say that, look, check, is this true? And have the research around that. Because what I worry about, and that's why at WIPO we're placing such a premium on communication, is that, and I saw this as one of the negotiators in the TPP, is that in developed countries there's a growing IP skepticism amongst the population. People feel that IP is part of this a way for big companies to get bigger, rich people to get richer, put it bluntly. And I think that's not healthy. I don't think that's true. I think people overlook the power of IP to lift up economies, and certainly that's been the case in Southeast Asia, where I come from. IP is part of Singapore's success story. It is part of the success story of Malaysia, Thailand, Vietnam, Indonesia, Philippines as well. But people don't see that, and I think the research that's going on in IP and the people doing IP research, the professors and in the universities, right? I hope that they will study this a bit more and then give, alongside with the economists and the multifaceted policy approaches in the IP regulators and in the governments, right? Give a much richer conversation around IP, because right now what I find is that the rhetoric tends to be black and white, and I think that's not healthy for the IP ecosystem.
Thank you.
Thanks, Daren. You'll be pleased to know that we do teach a course on IP into the second and third year of the science and the commerce faculties, but we should do more.
Fantastic, yeah.
The dean's heard, and we will. It's
not common enough. When we surveyed the top business schools in the US, the top 20 business schools in the US, I believe none of them teaches or has options on IP. And this is the US. So I commend on the leadership that you're showing in the University of Melbourne, and maybe the US has something to learn from your example.
We'll seek to continue that. Now we're going to move to actually what you would call the technical space with the next question. I know you said it's not unimportant. It is. You want to expand the space, but this is a technical question. Peter Frankie asks, what prospects for further substantive patent harmonisation do you see?
Well, I'll be very blunt with Frank. I think it's going to be tough to move big pieces of norm setting work. The big pieces of harmonization work, the patent law treaty, WCT, WPPT, the Singapore Treaty on Trademark Law, and all of that, right? All those happened 15 years ago, when the environment and appetite for norm setting work in Geneva and in international agencies was quite different. Now it's become a lot more fraught, and that's because it's not because of factors within our control. It's because of the geopolitical environment in the world right now. It's not just WIPO, by the way. It's affecting all the UN agencies around the world. And I'm cheering on COP26, but let's see what happens there. But I think you see where I'm coming from. It's tough. It's a lot tougher than it has been in a long time. So that's why I say that harmonization, I think we have to broaden our perspective on what norm setting work would look like. Rather than harmonization, right? Could we, and the way I see this developing is that we are still able to move very, very technical pieces of work. So for example, right, WIPO recently was able to get agreement from all 193 member states on the description of nucleotides and amino acids in patent documentation. It's called the ST26 standard. So in very, very technical areas like this, where it's not possible to politicize, things can still move. But once you get into things like what's patentable and what's not patentable, what's patentable subject matter, which is very political, I think that's going to be a lot tougher. So I think what we can expect there is that we can expect to have, maybe we need to have best practices, recommendations, guidelines, soft law, and give member states a bit of leeway, right, to draw on what's appropriate for them. So I think the days where we can move very big pieces of harmonization work, I think those become a lot more challenging. WIPO will not stop that, of course, be on the good hands of member states, but I have to say that's become a lot more fraught. And the other thing which I think we can try to bring value is that is to bring people together to talk. That's why these IP and AI conversations are quite important. We don't see these IP and AI conversations translating into norm-setting instruments in down the road. Not yet. No one's ready for it yet. But at least we need to get people to come together, talk about the issues that they face, and that way I think we can add some value. But the bottom line is that norm setting has become a lot more tough, not just for WIPO, but for all UN agencies. This is the world we live in right now.
Thank you. I could add that it would be great to have colour drawings possible in PCT applications in terms of an easier technical issue. But moving on,
that's good feedback, and yeah, we've gotten that feedback from quite a few IP officers too, and we're always trying to improve ourselves, improve our offerings. And we since I've got IPTA on this call, right, I'm going to make an appeal to Janelle to give us your feedback, because we do want to improve Madrid and PCT, and I think it's very important that we get user feedback. In particular, I think the use of Madrid is really underutilized. In many national IP offices, trademark filings are 4 to 5 times of patent filings. So Madrid at 60,000, 70,000 a year, PCT is at 285,000. I think there's a lot of potential for Madrid to grow. So, but we know that we can improve and we should improve our offerings. So Janelle, if there's some way we can reach out to IPTA after this and have a deeper dive into what we can do to improve PCT and Madrid, it would be wonderful to have the opportunity.
Yes, we'll definitely take you up on that. Thank you. I have a question here about universities and publicly funded research organisations. They
Yes.
generate, large volumes of IP. Yeah. And the question is, how can we facilitate better access to capital to take these to market, given the funding that created the IP is often quarantined from generating impact in the market? And how do we engage with policymakers to fund the transition across the valley of death in the pathway of commercialization?
It's a very, very important question, and something that's very high on the priority list of the new administration of WIPO. I think we came at this from a very simple perspective. A patent or a trademark or design or it's just a piece of paper if it remains in your computer or framed up behind your wall. That IP needs to translate itself into a product or service in order to create real impact. But that journey, as you know, from an idea to an IP is tough. But a journey from that IP into a product or services, right, is really, really challenging, not just in Australia, but in all over the world. And so IP commercialization is one of the areas of focus for WIPO. And in fact, I've set up one whole new sector at WIPO called IP and Innovation Ecosystems that will be looking at these issues. How do we help research translate and become commercialized, right, into actual products? Because that's where you create an impact. How do we help SMEs take their ideas to the market? How do we support IP-backed financing, IP valuation? And I mentioned that quite a bit in my opening remarks. It's not an easy area, because for that product to go to the market, you need capital, which is where the question is coming from. You need expertise, which is not easy to find. IP translation and commercialization expertise is not commonly found. You need good business acumen as well. So sometimes it's also about giving the founders, right, or the researchers or the innovators an ability to understand enough business to scale the business. Zooming in on this issue of funding, I think first the problem is that accounting rules and many of the rules around how we look at these assets have not caught up with the modern economy. For example, if you invest a lot of R&D into creating a piece of IP, and that's your, or it could be whatever, it's just an asset they create. You can't book that as an asset on your accounting books, and you have to book it as an expense in your accounting books. The only time you can book it as an asset is when you buy and sell. So what happens is that companies do transfer pricing and all of that, they buy and sell and subsidiaries in order to book it as assets, and that creates challenges, and because it shows that the modern system or the current accounting system still does not quite come to terms with an innovation-driven business model rather than a industrial manufacturing business model or resources or commodities resource model. So we need to address this issue. And at the same time, right, the problem that we get is a lot of small and medium enterprises and startups whose business is centered around innovation. They may have a couple of patents, a great 2 or 3 great brands, some amazing designs, right? But when you go to the bank and they ask for a loan, the bank will not give them, will not accept this IP as collateral. And this is all over the world. And in countries are trying to solve this. In certain countries, they're doing it in a very top-down kind of way. In China and Republic of Korea, it's a slightly more top-down approach. In Singapore, we tried a slightly more bottom-up approach. They all have their own pros and cons, and I have to say that it's not easy at all. So I have no easy solutions and answers to this question. But what WIPO wants is that we want to raise awareness of this issue to people, because there's a shocking number of people at the political level and at the policy-making level who have not even applied their minds to this issue. So what we need to do is that we need to raise awareness of this. We're going to start a series of dialogues on this. We want to reach out to the World Bank and the IMF on this issue, because central banks are not aware of this issue as well. I've spoken to central bankers, and most of them, for them, it's not on their radar. And we hope that over the next few years, right, when we bring together the worlds of finance and the IP professionals, plus the industry, plus the startup community and the policymakers, we can begin to direct their minds to this and say that we need to come together to help to address this issue. And it needs to be holistic. It needs to be addressed at the accountancy angle. It needs to be addressed at the disclosure level. It needs to be addressed at the bank financing levels, right? And I think this is a really, really important space for us to be in. So we look forward to your support to get this conversation going. And we hope that something can come up in a few years' time.
We've got a nice softball policy question for you now, Daren, just to let you off the hook.
Yeah.
Do you think that a TRIPS waiver would have an impact on global COVID-19 vaccine development over the long term? Do you think it would have a positive impact, a negative impact, or no impact?
So WIPO has made it very clear that we stand for vaccine equity. And I've said this in publicly on a number of occasions, but that we also think that IP is part of the solution in several ways. First of all, the vaccines, the mRNA technology wasn't created overnight, but it was created as part of this ecosystem that existed for decades, in which IP served as an incentive to bring investments into those healthcare innovations. So I think it's important to see IP as part of the solution. And what WIPO is trying to do is that we don't get involved. I mean, we are a bystander in a way in the WTO debates on whether that should be a TRIPS waiver. Our job there is not to add heat, but to add light. So what we offer to WTO is that we are trying to offer data and our expertise to understand the issues a bit more deeply, and the members there. At our own end, what we have done is that as a gesture to show that IP is here to help member states overcome the pandemic, we've announced our own package of COVID-19 support for member states. And we've told them that, look, when you look about increasing your ability to deal with the pandemic, when you think about increasing your ability of your healthcare system to address future pandemics, you need to look at it from an ecosystem point of view. If you take the IP, but you don't have the expertise and skills, you don't have the infrastructure, you don't have all of those, an ecosystem in place to deploy that IP into the ground, it wouldn't help, you see. So WIPO is here to help you to understand tech transfer, to understand IP licensing, WIPO Academy is here to train enough people in your government and in your private sector to understand IP from a very pragmatic angle. And please see IP as something as part of your solution. And so we've put aside 3 million Swiss francs just for COVID-19, and we have a package that supports member states. And what's also interesting is that in June this year, I sat down with DG Tedros of the World Health Organization and DG Ngozi of the World Trade Organization, and we announced a trilateral package where WIPO, WTO, and WHO will come together and offer our services jointly to member states, because overcoming the pandemic and increasing vaccine manufacturing capability is not just about IP, it's about IP, but also healthcare systems and also trade regulation. So we're coming together to offer our services jointly to all these member states in a trilateral manner. And we hope that all this will help member states understand that it's not that straightforward. It's not so, there's no one simple solution, but that we need to have, you need to look at it from a nuanced, multifaceted perspective again. So we're here to play a constructive role, and we hope that member states will take up this offer. And we hope that through these ways of working, right, we can show them that indeed WIPO and IP can play a very constructive role in this issue.
And we haven't got very long to go, unfortunately, and we've got lots of fantastic questions coming up. So I'm sorry to those whose questions we can't ask at this time. But one question in particular that interests me is that Australia has recently abolished its innovation patent system. Do you believe that a second-tier patent system has an important role to play in a country's innovation policy?
Yeah, so this is something that we studied in Singapore. And so I will speak more from my Singapore experience than from the WIPO experience. We looked at, well, utility models and all this all over the world. And in Singapore, we're wondering whether that will work for us. And I think the simple answer in a lot of IP policy making is that it really depends on what your country wants. There's no one size fits all. And it's not that it works, well, it works in Japan. So Japan has it, and I think it was working in Korea, and I think the Koreans are headed towards removing it, if I'm not mistaken. At least that's what they told me some years back. And it's still a minority in many countries. So I think in this policy making, right, there's no one size fits all. When we looked at it from a Singapore perspective, we didn't think it worked for us. And we looked at it from the economic perspective, we look at it from a development perspective. In the past, we would have just looked at it from a legal perspective, and then let's say which countries are doing it and then what laws are there. But when we crunch it from an economic perspective, I think it didn't make sense for us. And I believe that the commission, right, looked at it primarily from an economic perspective. So I think it really all depends on the economy, that economic structure and where you want to head towards that. There's always a downside, right, in giving protection. And so there's always a balance we need to make. Let me give you another example where we try to have this balance. When Singapore was wondering whether to give protection to colors, we thought that it would be better to do it through the design system than to the trademark system, because the trademark system allows protection forever, right? Trademark can be renewed indefinitely. And that could create economic outcomes that we don't want in the long run. But if we give it protection under the design system, 15 years in Singapore and 25 years in some other countries, or 20 years, there is a monopoly for that period of time, right? But then it's part of the design, but then it's not forever. See? So I think in a lot of this policy making, there's going to be a lot of these economic perspectives, and a lot of it's going to be not a one size fits all. So I can't answer that question categorically. It's not that it's going to be the bee's knees for every country in the world, but I think it's going to be a lot about what is it that the economic analysis tells us. So I think for those of you in IPTA that are still regretful about the change, I would say, do commission studies, economic studies that show that it's useful or not useful, and maybe that's one way to persuade your government, right? That for those of you interested, that they should be revived. But it's not going to be a one size fits all, and the same goes for many other types of IP as well. And that's why WIPO's mission is we quite carefully crafted to say that we believe in a balanced and effective IP ecosystem, because IP is a very powerful tool, you see, and you need skill to wield it. So let me be very clear. WIPO's mission of engaging the ground, bringing it to the grassroots, doesn't mean that WIPO is going to move away from being a technical agency. If anything, right, WIPO has to become an even more technical agency, because in order to help countries to skillfully wield this powerful tool called IP, we need to build the expertise, even better expertise, to help them to do it. But I think what WIPO needs to do, and I think what the global IP community needs to do, is that we need to not just be technical, we need to be bilingual. We need to talk technical language with fellow IP insiders and fellow IP experts. But once we are outside of those communities, when we're engaging with the business community or with university students or with 15-year-old kids who are setting up innovation clubs, or we're talking to musicians about IP or indigenous people, right? We have to talk in a way that they understand about IP. And I think that's a challenge for us. We've been so comfortable as a community of talking about IP in a very technical way. And that served us well, because it is a very difficult and highly technical area, that we sometimes are in danger of losing the larger community out there who see us as a priesthood of IP insiders, right? And for many of them, IP is intimidating, it's mysterious, it's enigmatic, and therefore they don't see it's relevant to their lives. And I think that does us a disservice, and in the long run, and will make us irrelevant in the long run. And that's what I'm trying to bring the message and hope that we can address together as a community. So I would say exhort IPTA, and I think there's LES and the IP Society of Australia and New Zealand, AIPPI is on this as well as sponsors, right? Go out there and engage with the communities that you're part of. Make sure that you tell the stories that you are of people that you're helping, the SMEs or the business owners that you're helping, the brand owners that you're helping. Tell these stories so that people in your communities understand that IP is not just a mysterious technical area but it's something that's very much part of their lives, about brands and designs and technology, content, right? And I think that's going to help us become more relevant and counter some of these narratives, right, that we're seeing where IP is only seen as of interest to big companies and highly industrialized economies, and of some danger to society at large, and an obstacle to equity and all that. We need to change that narrative.
Daren, thank you very much. As Janelle said, we've got a plethora of questions that we can't get to, but I know that you were very keen to come and visit us in Australia in person, yes. And it was with great regret that the obvious precluded that. I think what we need to do is ensure that you do come and visit us in person very soon, and you can answer these remaining questions and numerous others that will come up in the meantime.
I would love that. I would love that.
That would be
lovely
wonderful.
To visit Australia again, yeah.
Yes, but what I will do to bring our proceedings to a close now, I will invite the Director General of IP Australia, Mr Michael Schwager, to say a few closing words.
Daren, that was a fantastic presentation. There was so much in there that was rich, particularly about the importance of IP to economic growth, to jobs, and how important it is that we have to communicate that to everyone around us. As someone with an economics background, I fully support Daren's excellent comments on the IP system balancing economic and even social objectives. And we have to ensure that everyone benefits from the IP system that we have and that it's inclusive. And that's why, like WIPO, IP Australia is really focused on trying to ensure SMEs are included in our IP system, and that we look at the gender diversity in our IP system as a whole as well. Just like Daren was saying, we strongly support the idea that we have to look at the future of IP rights. What role is there for IP right monopolies in a future and the current economy with respect to intangibles, data, blockchain, artificial intelligence? And we're very happy to participate in WIPO's ongoing work. And even here in Australia, we plan to run quite a few discussions on these topics over the next 12 months. We're a very strong supporter of what you're doing, Daren, and the vision that you outlined for WIPO, especially the practical focus on getting the messages to the right people at the right time and collaborating with organisations to help multiply that message. IP, as we know, is a practical framework condition for innovation. Our challenge worldwide is to make it better understood, make it accessible and simpler to enforce. And we certainly would like to see our startups and SMEs better understand and use the IP system. So on behalf of IP Australia and the hundreds of people registered for this event, I'd like to thank Daren, Professor Christie, Janelle for their time and the insights this evening, and to the Melbourne Law School and to the Institute of Patent and Trademark Attorneys for making this possible. So a big thank you from IP Australia to all the people involved, and especially to you, Daren. Thank you.
Thank you very much, everyone. Appreciate it. Yeah.